I gather that quite a few of you watching are self-employed or operate small, medium-sized businesses, and indeed large businesses. So of course, you will face that inevitable problem of chasing late payments, invoices and the like. So is there anything you can actually do if somebody owes you money to G them up a little bit? Yes, there is. There's something called the Late Payment of Commercial Debts (brackets Interest) close brackets Act of 1998. And that was set by the government effectively to deal with this problem of people just stalling on paying debts. Because obviously, if somebody owes you money, you can eventually sue them. But how do you maximise the amount that you're going to sue them for? Because I've explained before about how damages work. Generally speaking, your damages is, the money you have lost. We don't have this punitive damages idea. You can only claim for what you're owed plus interest. However, the government sort of introduced a little scheme to, let's just say, encourage people to pay debts. And they did that by allowing you to charge quite a large interest amount, but also a fixed payment on every invoice to compensate for your trouble. So how does it work? First of all, this covers commercial debts. So this is things like between businesses. So, you've provided services or goods to somebody and they've just not paid. So when does the debt become officially late? If you agree a payment date, usually it's payment like 30 days if you deal with public authorities, or 60 days for business transactions. For business transactions, just straightforward commercial dealings between sort of private companies, private individuals. You can actually agree a longer payment term, more than 60 days, but it must be fair to both businesses. Now, it's interesting because I'm sure for the person who's meant to be paying, they'd be very happy with the longest period. But, people accept that, businesses do need to get paid eventually. If you don't agree a payment date, then the law says that the payment becomes officially late either 30 days after you give the invoice to the customer, or you deliver the goods or provide the services, whichever's the latest. But you can actually charge interest of, it's called statutory interest, and that's 8% plus the Bank of England base rate. So it's whatever the Bank of England are currently charging plus 8%. Now, you can actually agree a different interest rate in the contract yourself, but if you don't put an interest rate, then this is what the courts will apply. And you can also put in the contract, we will apply statutory interest. Now, can you start charging exorbitant interest? Then you get into difficulties because, like I say, because we don't have this idea of punitive damages per se, apart from acts like this, then courts generally don't like what we call penalty clauses, where somebody is being penalised for being late with something, but it's disproportionate. Although you'll probably see, if you've ever done any sort of like short-term lending on a property, something like a bridging loan, then if you don't pay back in time, then actually the interest rates do shoot up. And the courts have, upheld those and said, well, yes, although effectively it is a penalty clause because of the nature of short-term lending, and lenders need to know cash flow, need to know when they're getting things back because they've probably allocated that money to yet another loan, then obviously it has a big effect on them. So yeah, you can have what is effectively penalty interest. But that's not too bad, really, is it? So 8% plus Bank of Interest rate. I mean, I don't know what the Bank of English rate is at the moment, but whatever it is, you get that plus 8%. But also, for every invoice, you can charge a fixed sum. So up to £1,000, I mean technically £999.99, you charge £40. Between £1,000 and just under £10,000, £9,999.99, charge £70. And if it's £10,000 or more, you charge £100. And you can charge that on each invoice. Now, you've probably some of you will be doing the calculations going, well, hang on a second, I should always make sure all my invoices are for less than £1,000. And you can actually do that. So say, for instance, you're a builder and you're, invoicing on stage payments. I mean, lawyers quite often do this, of course. We will send you interim bills because it's rather strange. It used to be, and technically still is, that when you engage legal services from a solicitor and now, of course, barristers if you do direct access, it's what we call a whole agreement thing. In other words, the money only becomes due when you've actually completed all the work. But that can be a nightmare for cash flow, especially when cases rumble on for years. So we are actually allowed to bill you, more frequently. They're called interim bills. And interestingly, you get a difference between just regular interim bills and what we call interim statute bills, because you have a right to have your lawyer's bills assessed. If you think they're charging you too much, there is a way where you just go in front of a cost judge and a judge will look and say, I think those costs are reasonable, I think those costs are unreasonable. They do bear in mind privity of contract and the fact that, generally speaking, consenting adults can agree to pay what they want between people, which is very different from if you engage in litigation and then you are successful and the loser pays winner's cost thing kicks in. In that case, then there is all you've got to prove that every item was reasonable and necessarily incurred and is generally proportional to, the costs of the, what you were trying to seek to achieve in the legal matter. That's, as anybody's ever been on the receiving end of a cost assessment, that can be quite a harsh calculation. But when it comes to assessing solicitors' clients' own bills, the courts tend to be a bit more sort of generous to the lawyers because on the grounds you've agreed it. But you can only bring that within a year of the bill being presented. So say, for instance, somebody's charging you as you're going along, they invoice you every month or every 3 months or whatever. It's very easy to sort of go, well, I'll pay that now. And then at the end, you get to the end and go, oh, hang on a minute. Thinking about it, I think I was overcharged there back in the early days of this. It can be too late. Now, if it's just a regular interim bill, it doesn't meet certain conditions, then actually the time starts running from when you've made the last payment. But if the solicitors do it as an interim statute bill, and they'll quite often write on it, for the purposes of the law, this is to be considered to be an interim statute bill, then the time runs from when they first present you with it. So if you don't complain within a year, even if the work's still ongoing, you've missed out complaining about those particular bills. But yeah, in this particular case, like I say, you can invoice sort of at intervals or you can send separate invoices out and you can charge, like I say, the 40, the 70 or the £100 per invoice. You can only charge it once, of course, but then also you can charge the interest on top. And that interest carries on running until the debt is paid. So, it soon becomes a situation where it's a lot cheaper just to settle and pay the bill. And that's the idea. But let's say you have to do that and you have to sue. You'll get your piece of paper saying, congratulations, you are owed this amount as of today to be paid within whatever time period, like usually 14 days. And it'll actually say, with interest to run at a rate of X per day until it's actually settled. But enforcement, how do you actually enforce a bill? Because, I say on my website, I say, look, getting the piece of paper saying you've won is often the easy bit. Turning that piece of paper into money becomes harder. Well, you've got lots of routes of enforcement. You can apply to the court for things like attachment of earnings, where you can just say this person's receiving this amount of money, either from a job or through the benefits. I want an order saying a certain amount of it every week or every month whenever they get paid should come to me. You can trace assets and say they've got loads of money in a bank account. I want you to order that the bank has to hand the money over to me. And of course you can send the bailiffs round to seize people's property until they either pay or the property is auctioned. But bailiffs have relatively limited powers. I mean, they're private individuals, they're private companies or private individuals, but they are authorised by the relevant licensing authorities to act as bailiffs. There's also something called High Court enforcement. They're sort of super bailiffs. They have a lot more powers. For instance, regular bailiffs can't break into premises. If you don't let the bailiffs in and say, no, you're not coming in, or you just like make it impossible to get in. There's not a lot the bailiff can do except argue with you on your doorstep. High Court enforcement can do things like, you know, they can break into your car and just drive off with it, or they can sort of like get locksmiths in to enter business premises. How do you know, engage High Court enforcement? There's a couple of companies that do it. Again, it's sort of privatised, but they are all licensed and authorised. First thing you need to do is you need, because the name suggests High Court enforcement, you need it to be a High Court writ. Now, chances are you've just sued in the county court, so you've got a county court judgment, a CCJ. But you can actually convert those to High Court writs. You just apply, the fee's usually about £78, and then the High Court will say, okay, that's now a High Court debt, and you can pass it on to High Court enforcement. I mean, most of the High Court enforcement companies will actually take care of that process for you. Usually they'll want you to front the court fee, so you will have to, you know, invest the £78. But then when it comes to all the enforcement fees, because obviously they have to go around to these people and chase them, and there are certain amounts they can charge for doing that. So there is some control over that. But they actually then just chase, because the actual debtor becomes liable for those fees as well. So if you've got a piece of paper, sometimes it can be well worth investing the sort of 78 quid and just saying, right, I'm just going to leave it all to you. Give me a shout when you've got my money back, and whatever your fees are, you can just get them from the person. Usually when you take the contracts, you'll find that actually the enforcement fees are paid first. But, you know, it's just one way of doing it. It just saves you some hassle. So there you go. I mean, like I say, this is a video that'll probably get about like 4 views and like minus 12 subscribers. But, you know, it's just an interesting legal thing. And what surprises me, chatting to a lot of my business sort of friends in the pub and things like that, is how few of them are aware of this. Now, in the comments, you'll probably all say, yeah, of course we knew about this, but there might be somebody who didn't. So there you go. As always, hope you found this vaguely useful, vaguely informative, vaguely accurate, and that it is something that actually you yourselves can use. And like I say, I'll go here. I mean, I don't particularly need a sort of spectacular thumbnail for this because it's not exactly topical or controversial. I'm currently, while I'm pretending to work, I'm actually watching the live stream of that appeal about whether they can name the judges in the Sharif case. It's all very, very interesting because it's quite unusual to televise court proceedings in this country, but there are you know, ways that they can do that. And one of the things they do is they can televise Court of Appeal things. So it's all on YouTube, but they're just live streaming if you want to watch it. I'll just wait till the actual full judgment comes out, and then I'll give you my ill-informed thoughts on it. Did I pronounce that correctly? No, who cares?